Welcome, everyone. Welcome to the Employment Law Year in Review. We're going to go over the 2025 year here. And I am MyKhanh Shelton. I'm a mediator with ADR Services, and I'm the programs chair of the Beverly Hills Bar Association's Labor and Employment Law section. And I am delighted to introduce our speakers, Andrew Friedman and Anthony or Tony Oncidi. Andrew Friedman is a partner at Helmer Friedman. I think his reputation precedes him, but I'll give you a little bio. He primarily represents employees in employment law matters, including discrimination, harassment, retaliation, and complex wage and hour class actions. He also conducts neutral investigations into workplace disputes and occasionally represents employers and individual defendants. Thank you for being with us, Andrew. We also have Tony Oncidi, who's a partner at Proskauer Rose, where he co-chairs the Labor and Employment Law Department and leads the West Coast Labor and Employment Group in Los Angeles. He represents employers in all areas of labor and employment law, including class actions, discrimination, wrongful termination, and trade secret protection. He's been recognized as a top attorney by Chambers USA, The Hollywood Reporter, and the Los Angeles Daily Journal. Tony holds a Band 1 ranking for labor and employment. So we are so lucky to have you here, Tony. Thank you very much for presenting. And now let's get started. Over to you, Andrew.
All right. Can you all see my screen share? So, good afternoon. Today, Tony and I will be providing you with a discussion of those employment law cases from the past 12 months that we deem to be the most important. As always, I will be providing a clear-eyed, level-headed summary of those decisions, while Tony will provide a bombastic, flame-throwing, off-the-rails color commentary from the perspective of the true believing defense attorney that he is. Shall we begin, Tony?
Yes, let's go, Andrew.
All right, you're up first.
Yes, we're going to start with a couple of guidances that have been issued by the EEOC. Of course, if you practice in this area, as I assume most of you do, what happens at the EEOC, for the most part, stays at the EEOC and has very little effect on what happens in California, because we have, of course, a very well-developed set of statutes, regulations, and case law in California. But it's also of interest, I think, to sort of keep up with this, because there clearly are occasionally cases in which a federal claim is asserted under Title VII, for example, or the ADEA. This first guidance was issued last November, right before Thanksgiving, and it is a discrimination against American workers statement, identifying the fact that American workers are protected from discrimination in the same way that others of other national origins are. Again, I don't think this really makes that much of a difference in terms of what even occurs under Title VII, but it is the EEOC's statement, of course, consistent with the administration, that Americans are people too. It talks about discriminatory job advertisements and what they should and should not include, disparate treatment, including harassment and retaliation. And then it also says that, for example, common business reasons that might be used to justify national origin discrimination are not defensible or not defensive in these kinds of cases. They don't excuse an employer's decision to hire, and they give examples, for example, for customer or client preferences, lower cost of labor for non-American workers, and beliefs that workers from one or more national origin groups are more productive, excuse me, or possess a better work ethic than another national origin group. Again, I don't think that adds much, if anything, to the law in the area, but it is obviously a policy statement by the EEOC. This rescission referenced here happened just last week on January 22nd. Again, I don't think it's going to have really that much of an impact. This was a statement by the EEOC essentially saying that an April 2024 Biden-era enforcement guidance on harassment in the workplace, which was deliberately extended to sexual orientation and gender identity, has been rescinded as a result of this action of the EEOC last week. This primarily reaches examples that are included in this such as outing, a disclosure of an individual's sexual orientation or gender identity without permission. Again, that is no longer supposedly a basis under this guidance for a discrimination claim or a harassment claim, or misgendering, which is defined as the intentional use of a name or pronoun inconsistent with the individual's known gender identity. Then it talks about inevitably bathrooms and sex segregated facilities and individuals' gender identity. The problem with this, of course, from a legal standpoint, among perhaps other problems, is that it runs probably directly in the teeth of the Bostock opinion, which came out from the United States Supreme Court in 2020, in which the court, in an opinion by Justice Gorsuch, interpreted Title VII and its prohibition against discrimination and harassment based on sex to include gender and transgender individuals, as well as gay and lesbian employees, saying that that was on the basis of sex and therefore protected under the statute. The suspicion is that this will not be litigated much by the EEOC because the composition of the court has changed in the following way since 2020, when Bostock was decided. Justices Ginsburg and Breyer, both who voted in favor of the Bostock opinion, have been since replaced by Justices Barrett and Jackson. The suspicion is that Justice Jackson would probably vote the same way that Justices Ginsburg and Breyer, and I don't think anyone really knows how Justice Barrett might vote. But in any event, at best, the court would probably come down 5-4 at the best for someone trying to undo Bostock, because that was a 6-3 decision. So it probably, this rescission will stay as it is. It's interesting, but I think, again, it's not going to have much applicability in terms of litigation, nor especially will it have any applicability here in California.
So speaking of Chair Lucas ripping up these rights for the LGBTQ community, do we really need her to post on X the following, quote, "Are you a white male who has experienced discrimination at work based on your race or sex? Question mark. You may have a claim to recover money under federal civil rights laws," end quote. That's what she's posting at the same time she's ripping up these rights. Perhaps it would be better for Chair Lucas, who is an attorney, to spend her time doing better things, such as A, helping the Department of Justice wade through the millions and millions of Epstein files so that they can be released as they were supposed to be released last December 19th. Or perhaps she could help ICE comply with the 90+ court orders that they're violating in Minnesota alone, according to George W. Bush appointed Patrick J. Schlitz in an opinion that he issued yesterday.
At the state level, California, of course, is always busy, both at the court and in the administrative and legislative branches. Here, I think this new requirement kind of snuck up on some employers. It was created, this obligation was created as a result of a statute that was passed and signed by Governor Newsom late last year. The time frame, however, within which to do what I'm about to describe is relatively short because the state didn't issue the proposed template that employers are supposed to send to their employees in the form of a notice. You see here a reference to it. The actual template is, we've got it listed in our blog, and I'm assuming that it's fairly easily found if you do Google it. The California Department of Industrial Relations issued it in early January, and essentially it is a fairly comprehensive list of all of the things that an employer can be sued for, and then kind of topped off with, and if you want a union employees, this is how you get one. So obviously probably not a lot of employers are that happy having to turn this over to every single employee, but I think those days are long gone when employers could be offended by something like this. Among other things, it talks about workplace protections relating to immigration status. In fact, that probably is the bulk of what's in this, talking about what employees' rights are regardless of their immigration status. There's also an obligation to tell employees they have a right to designate an emergency contact and how to do that and what that must include. That is if they end up getting arrested by ICE or Border Patrol. There's also, as I said, a statement about your right to organize a union or engage in protected activity in the workplace. And then once again, references to the Fourth Amendment of the Constitution and what you do or don't have to do in the event that immigration authorities attempt to arrest you, and your right to remain silent. So and workers' comp. And then at the very end, it's got website links and telephone numbers for all of the California entities that are responsible for enforcing these rights.
So if you've attended
sorry, one last thing, and this is all supposed to be distributed to employees by February 1st. So that's Sunday. If you haven't done it, or if you haven't told your clients to do it, it's a good time to let them know. As I say, we've got a pretty comprehensive list of what all this is on our blog if you're in need of more information.
If you've attended our programs in the past year or so, you'll have noted that Tony and I, before we really get to the meat, like to provide some public service announcements to attorneys. And here's our first one. Dovirai no provir I. That's a famous Russian proverb that was uttered by Tony's hero. No, not Justice Scalia, who Tony will tell you within 5 minutes of talking to you that he was Justice Scalia's student, but rather his other hero, President Ronald Reagan, in describing the arms negotiations process with the Soviet Union, which is trust, but verify. However, when it comes to AI, Tony and I would like to change that a little bit, which is don't trust, but verify. The other quick public service announcement is that the courts are rightfully getting sick and tired of attorneys prosecuting or defending cases without factual support. And this is the first case I've really seen where the California courts come out and really lambaste attorneys for doing that. I think in the future, both the plaintiff side and the defendant side should be really careful about not pleading anything unless there is factual support.
One comment that I'll insert on the last Russian saying that you've said, although I assume you'll say more as we proceed today. This notion of citing cases that don't exist that are the subject of hallucinations by AI, which for whatever reason still exist. I don't know why you can't tell AI not to hallucinate, but apparently that doesn't work. There was an opinion that was published just this past week, or I think it actually was earlier this week, called Lifetime Well versus IBS Spot or ibspot.com. There's a Westlaw site, 2026 Westlaw 195644. It's from the Eastern District of Pennsylvania. It's a case in which it's a tale as old as 6 months, which is lawyers cited a bunch of non-existent made-up cases to a United States district court. Not a good idea. That was the first sin. The second sin is the same one that appeared in the case that go back to the last slide, Andrew, if you would. In this Nolan versus Land of the Free, the same thing happened in that case as happened in this district court case from the Eastern District of Pennsylvania, and that is that the opposing counsel failed to find the fact that there were fake cases cited. That's a really bad thing, and that makes the court even madder when its own staff has to find them. In fact, what the district court said is, our bar member admittedly did not read or study the case law. He simply signed his name. The paper he signed, along with a New York attorney, contained at least 8 false case citation hallucinations generated by artificial intelligence. Our talented lawyers in chambers caught these hallucinations, and we directed counsel to show cause as to why we should not impose sanctions, and they did, in fact, do just that. So I assume that everybody on this webinar doesn't cite cases that they've not read and have not verified are real, but if there is anybody that still is doing that, stop it.
And if you have done it Look at my materials. I quote extensively from a bunch of cases and from a Eugene Volokh blog where he talks about what you should do to fess up to the court so that you minimize your chances of getting sanctioned. We're going to move on now to our fun topic, whistleblowers 1102.95 and wrongful termination claims.
So this case, Lampkin versus County of Los Angeles, is an interesting one, and it's part of a series of cases that have come down since everyone sort of rediscovered what the actual requirements were for whistleblower claim to be asserted under 1102.5 of the Labor Code. Those of you who've been to our seminars in the past will recall that for the longest time, people were prosecuting and defending against, it was true on both sides, and having courts decide whistleblower cases based on the shifting burden analysis of McDonnell Douglas. No one seemingly ever actually spent time reading the statute, which has its own requirements and its own burdens within it. Somebody finally did do that, and in the Lawson case, LAWSON, the California Supreme Court said, yeah, that's right, that's what the statute provides. I was skeptical that employers would do as well, and I actually thought they'd do worse under the actual statutory framework. It turns out, though, that employers are winning, certainly at the appellate level, a number of these cases, and this is no exception. Here, this was a rather tortured tale. Andrew brought up Justice Scalia, so I'll have to, of course, mention him. He used to say in our contracts case that cases like this were a slice of life and would revel in the facts themselves. This was a case involving an employee who was a deputy in the LA County Sheriff's Department. He investigated a man whom he believed was soliciting a prostitute. In reality, the suspect was one of his retired law enforcement colleagues having lunch with his girlfriend. An altercation of some sort, which isn't described in the opinion, then breaks out between the employee Lampkin and the suspect, and then Lampkin reports the incident to his supervisor, presumably, who probably knew better about this former colleague who had this girlfriend allegedly that he was talking to at lunch. The employee then claimed that he suffered retaliatory actions by others in the sheriff's department, and then he sued the county under the whistleblower statute. The statute provides in this machinery that I've mentioned an affirmative defense for employers that it would have made the same decision, the employer would have made the same decision and taken the same actions, quote, for legitimate independent reasons. That's known as the same decision defense. And as I said, employers seem to be winning at least their share of those kinds of cases with that defense. In this case, the jury kind of went down the middle and they said, well, on the one hand, the plaintiff had proven the required elements of a whistleblower claim, but it also found, the jury did, that the county had successfully met its burden to establish the same decision defense. And so they found liability, but they awarded the employee no damages, and he was seeking only damages. The trial court, I think, wasn't exactly sure what to do with that. So what they did, the judge awarded the employee $450,000 in attorney's fees and costs after having, quote, successfully, unquote, proven a whistleblower claim. But the Court of Appeal reversed that award of fees and costs, finding that by definition, the employee had not been successful despite proving the elements of the claim because he had failed to prove any damages, and the county had prevailed in its same decision affirmative defense. So all kind of a mess, but a win for the employer nonetheless. The next case is another interesting case under the whistleblower statute, and we see this a lot. It's, I think, by nature of the statute, something that we're going to continue to see, and that is an employee has a thought in his or her mind about what is or is not against the law and believes that they are a whistleblower. The conundrum that comes up, of course, is that very few employees are actually employees and also lawyers. And so it is not unusual for an employee who is not a lawyer to think, probably after a Google search or not, that they have actually asserted a claim that is backed up in law. And this is a perfect example of this. This was an individual who mistakenly determined that his former employer was violating the state's Equal Pay Act by paying him less than his coworkers who were performing similar duties. Anyone who's looked at the EPA knows that there is another element that this employee was unaware of, which is that those differences must be, in terms of the wages, must be based on gender, race, or ethnicity. He did not have any evidence of that, though he believed nonetheless that the statute had been violated. Case goes to trial. There's a verdict of more than $182,000 from the jury, who also apparently didn't care that there was no real violation of the statute. And then the employer filed a motion for judgment notwithstanding the verdict, claiming that the verdict on the whistleblower claim was unsupported because the employee had misunderstood the EPA. And again, you can imagine that's somewhat of a difficult claim to make. That's why these claims, I think, inherently can lead to these kinds of results. The Court of Appeal reversed the grant of the JNOV and held that the employee who had a 10th grade education, though I don't think that really mattered in the end, had, quote, reasonable cause to believe that his former employer had violated the EPA, even though they had not. So employers face liability for whistleblower claims in this kind of situation, even when the employee has only a good faith but mistaken belief that there's a violation of the law. As you can imagine, that opens up the field for a lot of mischief. I'm not sure this case was an example of that, but I certainly have seen cases that were.
In this case, Cavry Management is a marijuana growing facility. It hires a guy named Stephen McDonald as an assistant grower. There's a robbery. Armed, masked men break in and steal about $70,000 in cash. Cavry decides to administer lie detector tests to all of its employees, including McDonald. It does not inform them of their rights under Labor Code Section 432.2, as they're required to do. When McDonald purportedly fails the polygraph test twice, they fire him. He then sues for wrongful termination using Labor Code Section 432.2 as the source of the public policy on which his wrongful term claim relies. The company moves to dismiss. The court denies it. The jury awards him $100,000. The employer appeals it, and the Court of Appeal affirms in a case of first impression, finding that Labor Code Section 432.2 does in fact provide a source of public policy for a wrongful termination claim.
Just in the hold on, go back for a second.
Yeah,
Just in the category of slice of life, this was my favorite part of this opinion. McDaniel had failed the polygraph exam twice, which caused him to be, quote, shocked beyond belief, scared, and, quote, this is the best part, worried that the career he had planned in the marijuana cultivation industry would be over.
It probably was. All right. Our next case is a little bit of a confusing holding. I'll do my best to try to simplify it. But Zoe Hollis worked as a stripper or an exotic dancer at a strip club named Sassy's. Hollis prefers the pronouns they and them, so I'll follow that preference throughout the summary I'm about to give you. Hollis sues Sassy's for violating the FLSA by misclassifying them as an independent contractor rather than an employee and not paying them appropriate wage and hours as the FLSA requires. Hollis, after they were fired, applies to work at another strip club called Dante's. Unfortunately for Hollis, the general manager of Sassy's was the same general manager at Dante's, a guy named Frank Falace. He rescinded her offer of employment at the second club, Dante's, telling them that the reason was they were protecting the clubs from potential future lawsuits. So
that second they you just used was not referencing the plaintiff, though.
It's kind of confusing.
Herein is the problem, yes.
And hard to do. So then Hollis amends their complaint suing Sassy's to allege retaliation. The district court grants Sassy's motion to dismiss because Sassy's was not a current employer at the time of the retaliation, nor was Dante's. On appeal, the Ninth Circuit reverses, saying that the employer does not have to be the current employer. And the Ninth Circuit did, on the broad remedial language of the FLSA and the remedial purpose to allow the suit to go forward, at least for purposes of proving that Hollis was an employee, in which case the FLSA would apply, as opposed to an independent contractor, in which case it wouldn't.
The only thing I would add to that near perfect explanation of the case, Andrew, is this important detail, which is the weekly variety show at which Hollis was supposed to work but was prevented from doing so at Dante's was Sinferno, Sinferno, Sinferno.
And what's really interesting to me, Tony, is that you can't find that information in anywhere in either of the decisions. Moving on to
I found it somewhere.
All right, we're going to move on to discrimination and reasonable accommodation cases. I'm not going to really talk about this case that much because we talked about it ad nauseum in 2023, 2024, and maybe even last year. But basically, the plaintiff twice lost before the Ninth Circuit on a finding that the plaintiff was unable to satisfy the McDonnell-Douglas burden shifting test. The plaintiff files a petition for cert with the U.S. Supreme Court, which denies the petition. However, two justices, very unlikely duo, come riding to the rescue of the plaintiff, issuing a dissent from the denial of cert, Justices Thomas and Gorsuch, and they say they would have accepted the petition to, among other things, clarify or overrule McDonnell-Douglas. It's too narrow of a test. It's too employer protective for them. So that happens in, I think, January or February of 2025. Then a couple of months later, another decision comes down. This Ames versus Ohio Department of Youth Services, and they still have such a burr in their bonnet about this that they issue.
I think you mean saddle.
Thank you. A burr in their saddle. What would a bee in your bonnet, or maybe they had both? That they issue a concurrence, again, specifically calling for this McDonnell-Douglas burden shifting test to be reevaluated because it favors employers too much. They keep telling people, file petitions for cert. Either the California Supreme Court or the U.S. Supreme Court is going to take up a petition for cert in one of these cases. Now, there was a little bit of a setback earlier this month when the Supreme Court denied a petition for cert in a case specifically asking them to overturn McDonnell-Douglas. But keep filing those petitions if you want to argue before either the California or U.S. Supreme Court cases, because you'll get there. Now, what everybody probably knows this case for is that it was called upon to decide a question of whether a majority group plaintiff had a greater burden in proving a discrimination claim than a minority group plaintiff. The thinking being that it would be a very rare employer who would actually discriminate against a majority group plaintiff as opposed to a minority group plaintiff. The Supreme Court issued a unanimous decision saying no, a majority group plaintiff does not have any extra special burden because of this unremarkable proposition: discrimination is discrimination.
So I'll start this one with the graphic, which I actually designed on our AI platform. And this appeared when Andrew stole it from my blog. But interesting case this one is, Sexton versus Apple Studios. This is a situation in which it sort of delves into the mysteries and delights of Hollywood. Apple was filming in early 2022 the limited streaming series called Manhunt, which is, I believe, still running on Apple. If you haven't seen it, I do recommend it. It actually is really good. And it's about the hunt for John Wilkes Booth in the days and I think weeks maybe following the assassination of President Abraham Lincoln in April of 1865. One of the conditions of the casting for at the very least, the vice president, Andrew Johnson, was that he be fully vaccinated. Remember, this was in early 2022 when all of that still made a lot of difference in the world. And Sexton, the plaintiff in the case, who had been conditionally approved for the role, refused to get vaccinated, and he sought an exemption on medical grounds. After considering Sexton's request, Apple ultimately decided that an unvaccinated actor could not safely be accommodated on the set of Manhunt, and they withdrew his offer, so that he did what any good red-blooded Californian would do under the circumstances. He, of course, filed a lawsuit claiming disability discrimination and related claims. In response, Apple cleverly filed a motion to strike his complaint under California's anti-SLAPP law, which of course stands for the Anti-Strategic Lawsuit Against Public Participation. It's a mouthful. And as you probably know, that's usually something that surfaces in exactly this kind of situation where there's casting being done by entertainment-related company, in their cases involving Broadway productions and television productions and motion picture productions, that those instances are situations in which the producers have a First Amendment right, essentially, to choose who to cast, and that the anti-SLAPP statute usually slaps out of existence claims that are based even on discrimination and related claims if there is this exercise of the First Amendment. This case is interesting in that the trial court denied the motion, but the Court of Appeal reversed and held that Apple's decision not to cast Sexton was in fact protected expressive conduct under the First Amendment, and also that his claims lacked merit because by remaining unvaccinated, he failed to meet the safety qualification requirement for the job. In terms of the First Amendment elements to this, there were two grounds. One was that Apple was exercising creative control and decision-making with respect to the selection of actors who would be contributing to the public issue of how contemporary viewers might conceive of Andrew Johnson. And so therefore they had maximum discretion essentially in choosing the person who would be personifying Andrew Johnson. And then second, and this is the part that actually goes beyond the realm of just entertainment, here it's the court said that by making a vaccination mandatory on the Manhunt set, Apple took a stand on the ongoing public debate about vaccination policy, which of course was a raging debate and the subject of litigation already back in 2022. So that second element is something that would apply potentially to all employers, certainly with respect to Apple, which was obviously very high profile, is a very high profile entity and employer, but I suspect other employers might be able to come within that element that might actually be able to, they might be able to rely on the anti-SLAPP statute if they are taking a public stance on a controversial public issue. Speaking of COVID, all these cases are now percolating through the appellate courts now, all the ones that got filed back in 2020, 2021, 2022, et cetera. In this case, against the Poway Unified School District, plaintiff by the name of Allos sued the employer based on the district's refusal to allow her to work exclusively from home. This is something that we've all probably either litigated or heard about, or maybe it's happened in a workplace you may be familiar with. That is your own. She worked as a senior business systems analyst and refused to return to work after the stay-at-home order was lifted in late 2020, which was actually relatively early for that. You'll recall that we're now at almost the 6-year mark of the beginning of the COVID situation. The trial court granted summary judgment to the district based on statutory immunity because it was and is a public entity. More importantly, for our purposes, the court also said that Allos was not disabled under the FEHA based upon a suspected or self-diagnosed allergy to vaccines. So again, this is something that pops up all the time. People can find just about anything on the internet, and these kinds of self-diagnoses were all the rage back in 21, 22, when people would go online and they'd figure out, they would, download a statement from a group or an entity or a person that they would then be able to put in. Now they could probably use Chat GPT to do the exact same thing and make it look somewhat real. But at the end of the day, what the employer did here was, I think, the right thing, which was to actually scrutinize the reason that was being given, and again, made the argument that this was a suspected self-diagnosed allergy to vaccines, and the court backed them up and affirmed summary judgment in favor of the employer. And then also COVID-19, you'll recall most of the claims by employees for accommodation either rested on religious points of view, which this case involves, or some kind of medical excuse. This one has actually both, and it's a very good, I think, example of it. It's from the Ninth Circuit. Here, the employee said that she is a practicing Christian who believes her body is a temple of the Holy Spirit and sincerely believes she has a, quote, religious duty to avoid defiling her temple, that is her body, by taking in substances that the Bible explicitly condemns or which could potentially cause harm to her body. Again, a lot of this, I'm suspecting, probably was backed up by things found on the internet. This took place in Oregon, and it was involving the Oregon Health Authority's administrative rule, which required healthcare workers, which she was, to be vaccinated against COVID-19 absent an approved exemption. So she does find these sources on the internet, and she says that COVID-19, she had concluded, that COVID-19 vaccines were created from fetal cell lines, I think you probably all have heard about this, and contain, quote, neurotoxins, and quote, and other potentially harmful substances. So then they tried to come up with a reasonable accommodation. She said she wanted a religious exemption from vaccinations, but they then said, well, how about, and then she said, I will wear personal protective equipment while in the office, and I will submit to weekly testing for the virus. However, she has a problem with the testing because the exemption from the antigen testing she wanted, she concluded, was based on these multiple sources, something that involved ethylene oxide, which is on the cotton swab inserted into the nostril for the antigen test. And she, of course, concluded that that, based on her sources, was a carcinogenic substance. So it went back and forth in terms of things she was finding on the internet and so on. Anyway, they eventually fired her. And she then sues for religious discrimination under Title VII, and under Oregon law, the court backs up the employer, as has happened in most of these cases, and summary judgment or actually I think it was the 12B6. Yeah, it was the 12B6 is affirmed. The dismissal is based on the fact that her, quote, specific determination of what is harmful was not in this case premised on the Bible or any other religious tenet or teaching, but rather on her research-based scientific medical judgments. And the Ninth Circuit said that is not sufficient to be the foundation for a religious or health-related exception.
Our next two cases illustrate the mischievousness of the McDonnell-Douglas burden shifting test and how it causes district courts to inappropriately grant summary judgment. So in this Liu case, the plaintiff, Dawn Liu, was a woman of Chinese ancestry who was suing the Postmaster General, alleging that she was demoted because of her race and gender and replaced by a white man. The Postmaster General moved for summary judgment, arguing that she could not satisfy her prima facie case under the McDonnell-Douglas burden shifting test because she couldn't show that a white man who had complained of gender and race discrimination was not demoted, whereas she had complained and she was demoted. So they're saying you can't find a comparable that's the same as you. The district court bought that argument, granted summary judgment. It goes up on appeal. And the Ninth Circuit sort of apologetically says, you know what, we're not really blaming the district court for this. Yeah, we see why the district court kind of ruled this way. Some of our opinions are pretty darn confusing on this subject, but no, To satisfy the McDonnell-Douglas burden shifting test in a termination or demotion, you don't have to find a comparable person. You just have to find someone who wasn't within the protected status who replaced you. The next case, Calderon versus Circle K Stores Inc., involved a couple of people who were let go, and they were claiming that they were let go because of their protected status, in this case, their age. The employer moved for summary judgment, contending they also didn't get promotions, that they couldn't sue for the promotion aspect of the case because they never applied for the promotion. And the district court bought that argument. On appeal, the Ninth Circuit reversed that, finding that you don't have an obligation under the McDonnell-Douglas burden shifting test to show that you applied for a promotion unless the employer was actively advertising for it. In this case, the plaintiffs were alleging that nobody knew there was this vacant position that people were available to apply to. They would have applied had they known, but it was secret. Now we move on to the more interesting cases, in my view. This one is a very boring, uninteresting one, but Tony,
I don't think so.
I know
This
you
is great.
don't. Yeah.
This is a great case. Well, it's actually for employers, it's half great. And the part that's not so great for employers, I think most employers would not run into trouble with, and I'll explain that in a second. So this is a situation where it's coworker against coworker on a sexual harassment claim. Of course, there's no strict liability in that kind of a case where there is no supervisor involved. It is whether the employer knew or should have known that the harassment was going on. And with respect to the first element of this, whether the employer knew or should have known, the employee fails to be able to show that on summary judgment that all of this sexual harassment that was allegedly going on was taking place outside of work and that the employer was not in any way involved. This was actually a female defendant who was sexually harassing allegedly a plaintiff, male plaintiff, and he alleged that he was subjected to crude sexual advances at his home and via his personal cell phone away from the premises of the employer. This all takes place in Bakersfield. Specifically, the employee said that the female defendant had sent multiple unsolicited nude pictures of herself, showed up uninvited to his house, and repeatedly propositioned him for sex. When he reported this conduct to Human Resources, the HR rep told him there was nothing that could be done, ostensibly because the alleged activity occurred off work premises. Probably most employers would not say or act that way, but in a moment you'll maybe understand the HR function at this employer. So that part of the case, in terms of the sexual harassment itself, the court says no liability for the employer because it did take place off of company premises. Rarely, by the way, in my experience at least, is it so clearly defined that the activity was not at all related to the employment. And of course, plaintiffs' lawyers such as Andrew are going to do everything they can under their power to try to connect this in some way to the employer. Andrew perhaps would have been able to do so even in this case, who knows? But in any event, the plaintiff was not able to establish any connection with respect to the harassment to the workplace. Where things go awry for the employer involves what happens next, and that is the HR rep not only says nothing I can do about it off premises, she then posts a video on social media depicting whining dogs and states, quote, "This is a work day at THR," I think it's supposed to be the office, and then LMBO, laughing my B, I assume is but, we don't know for sure. I'm not even sure it's defined in the opinion, but pretty sure that's what that means. So the plaintiff sees that. Obviously, he finds that to be somewhat mocking of him and isn't pleased by it. And then the HR rep, to put a cherry on top of all this, then sarcastically comments to the plaintiff as he's complaining about how she's not paying attention to the complaint. She says, she writes, I think, in a text to him, "I hope you don't get no more pictures," because that's good English. And so as a result of that, the court says, no, that's not how HR should react in a situation like that. So yeah, we got you out of the soup with respect to the harassment, but then you unfortunately ratified it and did all the wrong things when he did complain about it. So the court said that the hostile environment claim that he was claiming was viable insofar as the employer's response to the complaint altered his work environment in an objectively severe manner. Given the totality of the circumstances, the court held that the employer's refusal to take any action while simultaneously mocking the employee's concerns could indicate to a reasonable person that the employer had no objection. So everything was going fine until their HR people were notified of this. And then, of course, they destroyed whatever defense the employer would have had based upon how they reacted to the complaint.
Carranza is another terrific sexual harassment case where the employer gets into trouble because HR and management doesn't do anything. So in this case, Lillian Carranza was a police captain, and she heard, remember, heard, she didn't see, she didn't witness, she heard that people were sharing a photograph of a topless woman with the head cut off, and that people were saying it was her. She went to HR and to her bosses and other managers saying that she heard that people are spreading this rumor. The woman in the picture isn't her. She wanted them to notify everyone that she's not in the picture. She wanted them to order everyone to stop distributing the photo. And she wanted them to discipline whoever was distributing the photo. The city did nothing. So she sues, wasting taxpayer dollars. The city defends itself. They lose $4 million at trial. The city again then gets it with $641,000 in attorney's fees. Sorry about that. The city moves to set aside the verdict and on appeal argues that the woman, the plaintiff, did not establish severe or pervasive work environment because what happened to her was not hellish, quote unquote, hellish. That was the city's position. The Court of Appeal, citing the wonderful, terrific, fantastic Government's Code Section 12923, rejected the city's argument and said that even one incident of harassment may constitute a viable harassment claim. Then what I love at the end is the Court of Appeal writes, quote, FEHA does not reward discretion in harassing behaviors. Rather, it protects victims from workplace environments poisoned by inappropriate conduct, whether sung, shouted, or whispered. Bivens isn't a Ninth Circuit case or within our jurisdiction, obviously, so we won't spend very much time talking about it. I just want to cite it as a harbinger of things to come. Tony and I have previously talked about how Looper Bright Enterprises versus Raimondo got rid of Chevron deference. And now courts are free to make up whatever they want as to what they think statutes mean. So in this case, the Sixth Circuit abandons every other circuit's view and the EEO circuit's view of employer liability for third-party harassment. Under the new test that the Sixth Circuit thinks it knows better than the EEOC, employers will only be liable for third-party harassment, like the FedEx woman or the Postal Service, if the employer intends for the third party to harass the employee. I think it's a troubling development that we're going to see spreading to all sorts of areas in employment law.
Next.
Yep, there you go.
Okay, so this is the Court of Appeal opinion. It has been review has been granted by the Supreme Court in this case, so this is interesting, but as we indicate here, this won't be the final word on it. It will come from the Supreme Court. I will say, in full disclosure, our firm, in fact, my name was probably on it. We filed an amicus brief in the Court of Appeal, and we will also be filing one in the Supreme Court in support of the employer's position. This is an interesting case in that it kind of goes back to first principles when Andrew first started practicing so many decades ago. when Foley versus Interactive came out. Remember that, Andrew, back in
Never heard of it.
1988?
Nope.
47 Cal 3rd
I was in third
654.
grade.
Uh-huh. What Foley was all about was talking about, and nobody ever talks about Foley anymore, but it was groundbreaking at the time. And that is, if you are suing your employer essentially for a breach of contract, under what circumstances, if any, can you get tort damages other than, under a statute or under like a defamation claim as there existed here? Why this case was so peculiar, it did go to trial and on claims for retaliation, violation of the whistleblower statute 1102.5 and defamation. At trial, the jury found against the plaintiff on the retaliation claim, but found in his favor on the defamation claim and awarded him $2.16 million in compensatory damages. But the jury specifically found that the investigative report that resulted in the termination of the employee was a source of the purportedly defamatory statements. The employer moved for J&OV on the ground that the employee had conceded that his damages for the alleged defamation were simply his termination-related damages. And of course, they won on the termination-related claim. So basically, as a result of that, he had suffered no distinct reputational harm or other damages specifically attributable to the allegedly defamatory conduct. So in a 2-to-1 ruling in this appellate court opinion, they reversed the trial court's judgment entered in the plaintiff's favor on the defamation claim and agreed with the employer that the employee could not pursue a tort claim against the employer based on the same conduct and seeking no distinct damages from his unsuccessful wrongful termination claim. So it's a good law review article, I think, because it really does go back to first principles of tort, contract, Foley, all that. So we'll see what happens. We're all hoping, of course, the Supreme Court doesn't reopen this can of worms in terms of forgetting the difference between contract claims and tort claims, and then suddenly throwing everything into hyper overdrive, because every plaintiff's lawyer then will have a potential tort claim based on a breach of contract or some other non-tort related claim.
And what would be the problem with that?
I don't know. Waiting to hear from you.
All right. Moving on to attorney's fees. This next case, Bronstein, was an early Christmas and early Hanukkah gift for the defense bar and the plaintiff's bar. So for Christmas, the defense bar got a whopping lump of coal. You got a lump of coal in terms of several warnings from the Court of Appeal. One is, quote, when the plaintiff files a case with the prospect of recovering attorney's fees, the defense is fully entitled to fight hard, but the defense does so knowing it might end up paying for all of the work on both sides. And, quote, the fact that the defendant did not settle the case early might or might not be good litigation strategy or bad litigation strategy. But the biggest thing it does is it makes it hard for the defendant to claim that the plaintiff shouldn't have spent money litigating to try the case, which is reflected in the number of hours that counsel billed. For the plaintiffs, there are so many things here, I can't tell you all of them. Here are some of them. Court of Appeal affirms $4.9 million in attorney's fees to take a case through trial. Court of Appeal holds that $1,200 is not unreasonable for a Los Angeles attorney. Court of Appeal holds that just because you're at a small law firm, that does not mean your hourly rate should be lower than some big palatial law firm. I won't mention any names, Tony. And the court said that if a plaintiff has to turn down other work because it's handling a contingency fee case, the plaintiff's entitled to a multiplier. And there's so many other good holdings that we'll skip it and move on. But look at this if you're ever thinking about attorney's fees.
I'll just say, just briefly, I won't criticize anything in this opinion because it was written by the sainted Justice John Shepard Wiley Jr., my favorite appellate court judge anywhere, And he does say there's a holding in the case that fees, in this case, the plaintiff's fees, excuse me, in excess of $1,000 per hour is basically the going rate in Los Angeles. When we put this case up on our blog. That was the part that got highlighted by plaintiffs' lawyers, defense lawyers, insurance companies got mad, all kinds of hell broke loose. But Justice Wiley, hallowed be his name, has said it, and there it is, still published in the case.
All right. Employees file with the labor commissioner to get some unpaid wages. They lose. They appeal it to the trial court for a trial del nova, which gives them 140,000. They then ask for their attorney's fees, and the trial court gives them 200,000. The employer appealed, arguing that if you lose your Berman hearing, the hearing before the labor commissioner, you don't get fees after that. The Court of Appeal basically said that's nonsense. Of course you do.
So arbitration continues to roil, ROIL, everyone's daily 9 to 5 or 9 to 12 or whatever it is that we're all working these days. This is perhaps the poster child for how far the U.S., rather the California Supreme Court will go to try to save a case from being decided by the U.S. Supreme Court, because they have a really, 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 really bad record in front of the U.S. Supreme Court on arbitration issues. In this case, Hohenschelt involved this very, very bad, horrible, can't believe it exists statute, Section 1281.98 of the California Code of Civil Procedure. And this was, I view it almost as a tantrum from the California legislature saying, we are trying our best to make arbitration illegal in California. We've tried it 12 different ways. Here's the 13th way we're going to go. And what they did is they passed this ridiculous statute, which says that if an employer in an employment case or a non-consumer business in a consumer case fails to pay the fees that are charged by the arbitrator or the arbitration agency that is handling the arbitration within 30 days, it can't be 31 days, and you don't get any extra credit for mailing. You waive your right to arbitrate. They just invented this from nowhere. They actually say it is a material breach of the agreement, although of course that provision doesn't appear in anybody's arbitration agreement anywhere. So that statute comes out, and then for whatever reason, this became a favorite hobby, I think, of the California Court of Appeal, because there were no fewer than 12, and I think there actually might have been more than 12 at the end of the day, published opinions on this statute. And almost all of them, there was one or two exceptions, but almost all of them said that this statute means what it says, and employers, you're going to waive your right if you don't pay by return mail, basically, that the fees for the arbitration. And again, Justice Wiley, I already told you what I think about him. He wrote a dissent, or actually maybe it was a concurring opinion in the lower court opinion that appeared in this case before the Supreme Court took it up. And he said that that by effectively imposing a time is of the essence default presumption with respect to arbitration agreements, but not any other type of contract, because that's a no-no. The Supreme Court of the United States has already said an arbitration contract is a contract like any other, so you can't pick and choose. He said it was a dissent, he said in the lower court, by again putting arbitration on the chopping block, this statute invites a seventh reprimand from the Supreme Court of the United States. That was the setup before this case goes to the California Supreme Court. And then in what can only be described as an act of legerdemain, the California Supreme Court says, you know what, this statute is not preempted by the FAA, which of course is what Justice Wiley and others said that it would be. And there's no doubt that the US Supreme Court would view it that way. But there's only so much time in the US Supreme Court's day, so they can't spend all their time trying to fix California. And so the California Supreme Court said, this is not preempted by the FAA, but you know what? The statute doesn't really mean what it says. Yeah, we know it says that you waive your right after 30 days, but that's not really what it means. And they cite all of these provisions of contract law that are not ever referenced in the statute and are not made anywhere a part of the opinion. And they say that these generally applicable state law contract principles against forfeiture all apply. And as a result of that, unless the employer can be shown to have engaged in something other than a good faith mistake, in other words, if there is some activity on the part of the employer of bad faith, and it's not a good faith mistake, or if it's inadvertence or some other excusable neglect, then the employer doesn't lose its right to um, arbitrate. So essentially, what they did is they rewrote the statute. I don't know what this does to statutory interpretation law now, which says that a subsequent statute is presumed to know about existing statutes already and supersedes generally those pre-existing statutes if it has a different outcome. But the Supreme Court has made the bed and now it's lying in it. I guess this won't go to the US Supreme Court, but one day probably this statute will in some form or another. Wilson is the first case, I believe, that's been published after Hohenschelt. Applying Hohenschelt, they got with the program, and now the Court of Appeal sees, after all, this is a dumb statute. And unless there is, quote, willful or grossly negligent or fraudulent activity on the part of the employer, the employee cannot get attorney's fees and cannot essentially access back into the court if there is a arbitration agreement that is otherwise enforceable.
Let me just briefly mention this Avery case. It's fresh off the presses, came out yesterday afternoon. It's fascinating the machinations that employers will go through to avoid wage and hour cases and imposing arbitration. So with a class action certification motion pending, the employer rushes out by email a statement saying that every single employee is now covered by a binding arbitration agreement with a class action waiver unless you quit immediately. Then maybe someone at the company thought, did we run this by the lawyers? All of a sudden they rush out another email that says, but if you're a member of this putative class and this Avery putative class, you can opt out by filling out the attached form and sending it in. They then file a motion to force to arbitration all of the putative class members, or actually by this time the class is certified, so all of the class members who failed to opt out of the arbitration agreement. The district court and then the Ninth Circuit said, no, you're playing games. That your attempt to get these people to opt out of your arbitration agreement violates the class action procedures and it's not going to be enforceable. Do you want to talk about
What's that?
Do you want to talk about this Helfer case?
Yeah, just briefly. I mean, this plays right into Andrew's ridiculous theory of the world, which is that every employer always does this, which is they have in their back pocket an arbitration agreement. They're sneakily keeping it there and just waiting for the moment in which they can drop the arbitration agreement only when they think they're not going to do better in court than they would otherwise do in art. Some ridiculous theory. Ask him about it. He'll tell you probably all about it in an email that's about 12 pages long. But it does look like something weird like that happened here, although it wasn't a dastardly defendant, it was a dastardly plaintiff. Here they initiated litigation against the defendants, notwithstanding the existence of binding arbitration. For 6 months following the filing of the litigation, they sought two forms, that is, the plaintiffs sought two forms of preliminary injunctive relief, opposed a demurrer, propounded more than 700 discovery requests, demanded a jury trial in their case management conference statement, and represented they would be litigating substantive motions in court. And then they posted jury fees. It was not until the opposing party filed a cross complaint that plaintiffs got religion, and they filed a motion to compel arbitration. As you can see, that really shouldn't be. I don't care if it's the plaintiff or the defendant that does it. The trial court, I think, properly denied the motion on the ground that plaintiff's conduct in the case constituted a waiver, citing Quach, Quach versus California Commerce Club, California Supreme Court case from 2024. The Court of Appeal affirmed the denial of the motion to compel.
This is a really fascinating case. The plaintiff sues for sexual orientation harassment. The employer moves to compel arbitration. The employee opposes the motion to compel arbitration, but does not mention the Ending Forced Arbitration of Sexual Assault, Sexual Harassment Act of 2021. Instead, the trial court brings it up on its own and denies the motion to compel arbitration. It goes up to the Court of Appeal, and the Court of Appeal said, well, yeah, of course, a court in determining whether the FAA is applicable has to look at any carve-outs to the FAA. So this was a perfectly good reason to deny arbitration.
So let me stop on this. This is one of my pet peeves these days. And this Andrew and I co-authored an article that I think is in the materials that have been distributed for this conference, or this webinar, sorry. And in our article, we talk about this very issue, which is that there are a bunch of things that are happening now that this Ending Forced Arbitration Act, the EFAA, got passed. And among other things, the plaintiffs' lawyers now are sprinkling, or maybe I should say, bombarding every case that they file, no matter what it involves. If there's employers on the other side, it could be a wage and hour case, it could be a whistleblower case, it could be a religious discrimination case. They now somehow find sexual harassment and sexual assault under every rock imaginable, and then they drop one of these causes of action in the case. Now, the case law in California is uniform on this, which says, number one, employers, if there is a sexual harassment or sexual assault claim in the complaint, in the case, because that's the ridiculous language Congress used, there's all kinds of ridiculous language in the statute, the entire case is immune from arbitration. So guess what? All the plaintiffs' lawyers now are finding reasons to put sexual harassment and sexual assault in all of their cases because one little tiny allegation of sexual harassment or sexual assault is enough to poison the well and prevent arbitration, because there's nothing plaintiffs' lawyers hate more than arbitration. They will do anything under the sun to try to prevent it. And so that's happening a lot. And so we see that a lot. We're seeing those. One of the questions that always arises now is, what if it's not really a substantial harassment claim, and that it's really just put in there for these kinds of purposes? I deal with that on my section of the article. I'm not going to go into that right now, but that's one defense that employers have, that it's got to be something more than just non-frivolous, which some of the courts are now saying. Secondly, the thing that happens in this Quilala case, which I had come up in the LA Superior Court just a week or so ago, is that the case, rather the statutory language says sexual harassment or sexual assault. Plaintiffs' lawyers now have somehow forgotten how to distinguish between a sexual harassment claim and a gender-related discrimination claim. To them, they're profoundly confused by this. No one can understand it. And so anything that involves sexual anything, they're now saying is sexual harassment. This is a perfect example of it. This gentleman claims that he was discriminated against or harassed on the basis of his sexual orientation. But if you read this, there's not really any sexual harassment in here. He says, among other things, that his supervisors asked, quote, intrusive questions about his sexual activity and mocked him by referring to him as Mrs. Quilala before he was fired. Those things, I submit, do not have anything to do with sexual harassment. That is, if anything, discrimination or harassment based on sexual orientation. That is not sexual harassment. It's not what Congress meant. It's not even what Joe Biden meant when he signed the EFAA. My example I had a couple of weeks ago, the judge in the tentative ruling, which was 15 pages against us, didn't even, for whatever reason, analyze this. It was it was a gender discrimination case in which the employee, a single employee, was claiming that female employees, they were security guards, got less favorable assignments than male security guards. Sexual harassment. And so they said that's sexual harassment. The judge in the first go round in the tentative ruling that I was facing with 24 hours to go said, yeah, that's close enough sexual harassment. I spent the entire 10 minutes or so allotted to me during oral argument and convinced the judge in his final ruling that that wasn't sexual harassment. We actually now have that write up on our blog. Again, I would recommend anybody who's facing this, because it's all over the place. They're all doing it in every case. This is one way out. The judge's ultimate order was a very good one. It's very long and meaty, and it talks all about the difference between sexual harassment and sexual assault, rather sexual harassment and assault on the one hand, and gender discrimination on the other. And it's also published on Westlaw, so you can cite it for whatever it's worth. It's an LA Superior Court opinion, which obviously only has persuasive value.
In our next case, Carla Velarde started work at this company, and she was presented with a stack of documents, 31 documents that she was told to review and sign them quickly so that she could start work and start earning money. As she was signing the documents, she was actually reading them, and she saw that one of them was an arbitration agreement. And she said to the HR person who was hovering over her, I can't sign this. I don't know what it means. And the HR person says, oh, this just means if there's ever a dispute between us, we can resolve the thing really quickly. Neither one of us are going to have to hire lawyers. It's all kumbaya, my friend. So the person signs the thing. And she actually asked, do I have to sign it? The HR person says yes. Later, of course, there's a dispute. She files a lawsuit. The company moves to compel arbitration, and she argues that the agreement was procedurally unconscionable because she was forced to quickly sign it, and it was contained in a pile of 31 other documents. Court of Appeal agreed with that. The Court of Appeal also found procedural unconscionability because she was misrepresented about what the arbitration agreement actually stood for. And the Court of Appeal sort of double dipped and found substantive unconscionability because she was misrepresented as to what the arbitration agreement meant. And basically, the Court of Appeal said arbitration agreements aren't going to get you a fast, speedy resolution, contrary to the promises of the HR person. And in all likelihood, both sides are actually going to have to hire lawyers rather than just doing it themselves. So the Court of Appeal sustained the decision not to compel arbitration.
I would say on this, there's much to be learned for employers in this case. The court actually said, had the employer either correctly explained the terms of the agreement, which it didn't, or had not explained them at all, which it could have done, and had given Velarde a reasonable opportunity to review the agreement and to consult counsel, this would be a different case, but that is not what happened here. So this is a good opportunity to train the HR people who are interacting with employees under these circumstances or prospective employees, not to try to characterize what's in an agreement, because it will be used against the employer, obviously, as it was in this situation. So they should not attempt to play armchair lawyer in inducing an employee to sign something like this. They should say, the agreement is what it is. I can't really give you advice on it. If you want a week, 10 days, whatever to look at, you can do that. I mean, I know not, a lot of employers really can't do that in their onboarding, but something along those lines so that they're not being tagged with a misrepresentation or an alleged misrepresentation about the meaning of what is otherwise a potentially complicated document. The other thing I'll say is we're going to get to it, I think, but we're running out of time here. Another case called Wise versus Tesla Motors, which we've got further on in the outline here. That was a similar situation where there was a motion to compel arbitration, and the court severed the provisions that were in a non-disclosure agreement that were problematic, and then did enforce the arbitration agreement. So that's sort of the last refuge of an employer in these circumstances to say, no, nothing wrong with the agreement, nothing wrong with the agreement. But if there's something wrong with the agreement or other agreements, they should be severed. Sometimes you win that, sometimes you don't. The Wise versus Tesla case, it's 2025 Westlaw 3707196. 3707196 is a good example of severing the problematic provisions.
Really quickly on a few of these arbitration cases, Tesla wins an arbitration award. It moves to federal court to confirm the award. The district court confirms the award. There's an appeal. The Ninth Circuit reverses and instructs the district court to dismiss because since Tesla won, they won a $0 award. There wasn't $75,000 at stake, so there's no jurisdiction in the federal courts. Casey rebuffs employer attempts to get around the FAA and the EFAA. So some employers are now saying that arbitration agreements are governed solely by the California Arbitration Act, and therefore the Federal Arbitration Act doesn't apply, and therefore the EFAA doesn't apply, and sexual harassment cases have to be arbitrated. The Court of Appeal said, no, you can't. Federal law preempts state law. You can't get around the EFAA that way. This is one of those cases where Tony kind of highlighted what I was going to argue, which is that employers wait for years and years and years to see how things are going in court before they move to compel arbitration. Here, it proves my point exactly. The lawsuit was filed in October of 2018, and the employer did not move to compel until 2023. All right, here's the Weiss case that Tony was going to talk about, which also addresses another issue, and I'll let Tony have the floor really. But what this addresses, employers realizing that arbitration agreements can be voided out if they contain unconscionable terms. They're moving those unconscionable terms to other documents that they make the employees sign at the same time they sign the arbitration agreement, and the courts are saying, no, no, no. Anything that's signed at the same time as the arbitration agreement needs to be examined for unconscionability purposes. Do you want to add anything?
No.
Right. Okay.
P Mortgage is a recent Ninth Circuit opinion. This just reaffirms what we already all know, I think, which is that one of the darker alleys in arbitration has to do with seeking appeal when something goes wrong in the arbitration. In this case, the arbitrator, quote, forgot about a stipulation that had been brought to her attention, in which that stipulation provided that the attorney's fees would be borne by each side, and she did award attorney's fees irrespective of the provisions of the stipulation. To her credit, or I guess in her defense, really, the Ninth Circuit said that the district court was correct in not upsetting the award of the arbitrator, even though there was clearly an error with respect to attorney's fees, because the arbitrator had previously approved that stipulation, but the parties had failed to bring it to the attention, I guess, to remind the arbitrator, because they had briefed that issue over a year previously. I don't know why an arbitration would take a year, but sometimes I guess they do get elongated. I've had that situation, not as long as a year, but in any event, this whole issue of the stipulation had been brought to the arbitrator's attention a year before, and it wasn't something that either side reminded the arbitrator about before she issued her award. And so therefore, the court held that the vacatur, I think that's how you pronounce it, VACATUR, was properly denied because the error was not so obvious and undisputed that the arbitrator must have known about it when she decided the legal issue. So again, a very, very pro arbitration, anti-reversal bias that is just built into the law in these areas.
Tony, don't you want to comment about the cat images? No? Okay.
This is one of a couple of recent cases in which volunteers are at issue. And here, these two, or actually three plaintiffs, were full-time workers for the Salvation Army at one of their retail thrift stores. They worked without wages as part of a 6-month residential substance abuse rehabilitation program. Then, of course, they did what any good red-blooded Californian would do after that and sued for wages that they apparently never should have thought they were going to get. The trial court determined that the wage and hour laws do not apply because these three individuals were volunteers for a nonprofit and not employees, based principally upon the absence of an agreement for compensation. That's kind of where the trial court went off the rails. The Court of Appeal didn't like that and held that the existence of an agreement for compensation is not a dispositive test as to whether the individual is a volunteer or an employee. So the appellate court remanded the case back to the trial court to determine whether there are triable issues of fact as to whether these were actually volunteers who freely agreed to work without pay, and whether overall the Salvation Army's use of volunteer labor was used as a subterfuge to evade the wage laws. So more work to be done on that.
Okay, if attorney solicitation was not unethical, I would advise every defense attorney in the room to rush out and seek to represent Bridgeville Property, Inc. and its owner or manager, Cynthia LaPelli, because Rather than pay an employee $100,000, they must have paid their defense lawyers millions of dollars to take this case up to the Court of Appeal, not once or twice, but two times, and to the California Supreme Court twice. Now, in this decision, which was by the California Supreme Court in August of last year, the Supreme Court, in a case of first impression, basically said that in order for an employer to establish a good faith defense to a liquidated damages claim, it has to show that it actually made some type of reasonable inquiry or determination to show that it tried to comply with the law. It can't just sort of think that it's complying with the law and be entitled to the good faith defense. Then, in the follow-up to the Supreme Court decision in December of last year, the Court of Appeal held that the CEO of the corporation, who had not paid or basically made sure the employee didn't get paid, that CEO was personally liable for the wage claims of the employee. Is this you?
Yeah, let's skip this one. We're
Yeah.
okay. So this one I love just because the title, "The Merchant of Tennis," get it? Versus Superior Court. Here, this is an example of something that employers try to do. I tried to do it once. It almost always goes awry, and this is a situation where there's a putative class action, and the employer decides they don't want to be involved in this class action nonsense, and they go and they try to settle individually with employees. It's sometimes referred to as a pickup stick settlement, because the original case, or one of the original cases where this was tried and upheld, actually, it involved the restaurant. I don't know that it's still in business, Pickup Sticks. Here, the employer entered into approximately 954 individual settlement agreements with employees, by which it had paid $875,000 in these individually negotiated settlement agreements. But something went wrong, as it almost always does in these kinds of situations, and the trial court concluded that the ISAs, the individual settlement agreements, were voidable due to alleged coercion and fraud that existed. And then they ordered the parties to give a curative notice to all putative class members, advising that they could revoke their ISAs and join the class action lawsuit. Of course, the employer's like, I just paid $875,000 and all I got was this T-shirt. So they wanted to know what was next in terms of trying to get out of this case. There's a lot of back and forth about what the curative statement needs to be or what it doesn't need to be. But ultimately, what the Court of Appeal said was they did grant a writ, and they said that the required notice, the curative notice, that employees who rescinded their ISAs, they could be responsible for repayment of the settlement proceeds at the conclusion of the litigation, which wasn't exactly what the employer wanted, because the employer was, of course, trying to make the employees think that they may immediately lose what they had been paid. And then this was subject to the trial court's discretion to adjust the equities between the parties. So it was kind of not exactly what the employer was looking for under those circumstances. I only have one other case I want to mention. Andrew, do you have one last one you want to talk about?
Yeah, I know what you want to talk about. You want to talk about this one. You love this case.
I love this case. So this was not an employment case. This was a defamation case, but it hit a nerve with me because I've had several of these cases, both in California and in New York, where every plaintiff now is coming up with this brilliant idea of suing pseudonymously. Pseudonymously. When's the last time you heard that word? P-S-E-U-D-O-N-Y, musly. And that basically means that the plaintiff sues as a pseudonym, usually as John Doe or Jane Roe, whatever, and of course doesn't provide the same benefit to the defendant. In this case, actually, they did. Both the plaintiffs and the defendants were not identified in the complaint, but this involved the non-party that was the defendant had a motion that was basically filed to unseal, and this motion to unseal was filed by the First Amendment Coalition, a third-party nonprofit, and the idea was to unseal the plaintiff's true names, which the trial court denied as being premature. The trial court then directed plaintiffs to file a motion to maintain their anonymity. All parties filed motions to proceed under pseudonyms, both the defendants and the plaintiffs, which the trial court granted. The coalition filed an appeal as to the granting of plaintiff's motion only, and the Court of Appeal reversed the trial court's grant of plaintiff's motion, holding that a party's possible personal embarrassment standing alone does not justify concealing their identity from the public. Further, the court disagreed that a, quote, reasonable fear of one's employer, so employment is mentioned, learning about allegations of a private nature overcame the public's right of access. That does not, in fact, occur under most circumstances. So what does all this mean? It just means that if you are facing a case, as is very common now, for where the plaintiff wants to proceed anonymously, but wants to smear the defendants all over the place with all kinds of allegations that are subject to the litigation privilege, so they can't be sued for it, consider very seriously filing a motion like this using the Roe versus Smith case.
I just have one brief one. Is there one you wanted to cover in addition to this one?
No, I'll talk about this one again, though.
Okay. All right. So I want to just talk about, where are we? This one. Sorry, this one. So in this case, this is not an employment case. The lawyer for the deponent is sitting in the same room with the deponent. The lawyer for the deponent, though, it does not have, I think it's does not have his video on. So the person taking the depo only sees the deponent. And I guess there was some concern on the person taking the depo's part that the lawyer was coaching the deponent because the deponent kept looking away from the camera, pausing, and then giving answers. So they asked the deponent's lawyer to go on camera. The lawyer refused. They file a motion for discovery sanctions, and not surprisingly, and I think properly, the lawyer for the deponent was ordered to have his or her camera on when they're in the same room as the deponent, and was ordered to pay $9,981 to the lawyer taking the deposition. That could be it.
I think that is it. That's all the employment law.
Let's stall it out till 5:30. We have 3 more minutes. This is an interesting case that everyone should read because it's going to happen more and more often. Let's say there's a settlement and there's a check that goes out or an electronic funds transfer that goes out from the defendant or the defendant's counsel or insurance company to the plaintiff, but somehow a scammer gets it. Whose fault is that? I mean, is the defendant or the plaintiff out of luck? Is the insurance company going to have to write another check? Well, this case walks you through, it's a non-employment case, but it walks you through how to figure out who is liable. And one of the things it does is a very common sense thing, which is that if you're the one writing the check, you get a phone call saying to send the check somewhere else other than what the settlement agreement says, you should probably pick up the phone and call the plaintiff's lawyer and say, hey, I got this weird phone call. They want the check to go to this Chinese bank or this Russian bank. Is that really where you want the funds to go to?
All right. Thank you all for coming. We unfortunately we can't see you, but you can see us and we'll wave goodbye. We're really happy to have been invited back. Andrew wasn't as rude as he typically is, so maybe we'll be invited again next year.
Hopefully so.